Well, we're coming up on an important anniversary. It's actually the anniversary of the death of a patron saint, and the legend has it that this patron saint was able to chase all of the snakes from outside of the Emerald Isle, and didn't know what it was already. The anniversary in question is the 17th of March, St. Patrick's Day, which will soon be celebrated right here in Chicago, where they dye the river green. And it's a day filled with revelry. A lot of alcohol is consumed, but this day is actually an important day on a personal basis for myself and my frequent collaborator, Mike Bomarito, because on March 17th of 2009 is the date where the two of us sat outside of this building right here, which is West Hall at the University of Michigan, in front of a hot dog truck. I couldn't get that in, so I went to the clip art for that. But we started discussing creating a blog, and the blog was going to be devoted to kind of relevant emerging trends that we thought were interesting. And this blog would end up being called Computational Legal Studies. And so it's so I want to take you back to 2009, if I might, and set the scene, if I could. You know, after many decades of what might be called intellectual exceptionalism, the academic field of law was witnessing a very positive trend that was taking place back then. It was an effort to kind of align with mainstream movements within broader universities. What was happening at that time is there was an empirical turn in legal scholarship that was really finally becoming mainstream. And just a few months before our trip to the hot dog truck, we had Mike and I went to the third conference on empirical legal studies, and you know, it was at Cornell University, and it was you know, there was real momentum behind these ideas, and I'd say that this was putting the field of law really on the path to modernity and looking like other fields, academic fields of study. This tension in the field had been building for a long time. You know, law faces a credibility revolution where, and it did at the time, it still does to some extent, where we have lawyers and judges and policymakers and law professors kind of attempting to craft legal rules and doctrines, and even criticizing legal rules and doctrines, but really doing that with almost no empirical focus on the actual real world performance of any of these rules and doctrines. And that's something that's very out of line with the way the rest of the academy is organized, at least the technical side of the academy. So this trend was a very positive one, which is we saw, you know, legal scholarship becoming more empirical in nature. So many schools in the years that followed have created centers associated with this topic, empirical legal studies. And so, you know, that we viewed as a very positive trend. If you look at empirical legal studies, it typically takes on a particular type of perspective. It's born out of regular legal studies, so it sort of starts with this framework of the lawyer as a policymaker or an appellate judge. Now, that's obviously not the only frame one can bring to bear, but it's often how law school is taught historically. And so when people started doing empiricism, they sort of mimicked a lot of what we saw in terms of the questions they pose and the methods they bring to bear. So if you look at the methods, the people look at, hey, what's the best policy intervention to achieve a particular end? And, you know, drawing from social science, people might bring regression type models to bear to do policy evaluation. And then what happened in the field is it got more sophisticated, more economists got involved, and you see kind of econometric methods coming into the field. So things like this, IV, causal, and basically the causal inference toolkit is brought to bear. You know, the thing that we have in policy evaluation is that we can't generally do a randomized control trial like you would if you were testing a medicine, where you give one group the placebo and one group the actual medicine. So a lot of the effort there is to try to leverage methods to get a synthetic version of a randomized control trial. And so causal inference is really appropriate to me when cause and effect is the goal, the thing we want to pin down. And this perspective has made real headway within the legal academy. I mean, if you went on to SSRN right now, there are thousands of empirical legal studies papers, over 8,000 of them published, many of them in the last 10 or 15 years. And so it's an ascendant trend that is kind of highly mainstream now, but wasn't 20 years ago. So it was against this backdrop that we kind of entered the scene with this computational legal studies stuff that we were interested in. The kind of theory of the case was advances in computational technologies were going to be somehow relevant for law. And it was a calculated bet, and it turned out to be right. It would show up in different flavors on different timelines, but you know, here's kind of three flavors of computational law. One is social science kind of the social science work I just described, but where people take computational methods and they try to do things, particularly on the front end, like data pre-processing, creating really large data sets and cleaning them using computational tools. So it's really the traditional stuff I mentioned in empirical legal studies, but with a computational bend or flavor to it. The second kind of bucket that you see is social physics-y type papers where people are bringing physics types models to bear on laws and applied domain. So I'd say the first one is kind of social science, the second one is science/physics, and the third one is engineering. The third one is using computational techniques to actually build legal technology applications. That's more on the engineering side of the house. Again, if you looked at the technical academy, this is a very familiar kind of division of things. There's a science side and an engineering side. All of these things, these ideas have moved up and to the right over this period. So if you looked here, not that the Google books and Graham Viewer is the only thing out there, but if you were to take a look at it, you'd see pretty significant growth in legal tech, pretty significant growth in these phrases like computational law or computational legal, but a pretty significant separation when you overlay them on top of one another. So that's one thing that didn't play out precisely as we expected. I mean, but kind of seeing that really aligns with my personal experience in the years that followed, which was to the significant extent, and that the commercial world is further out on some of these ideas than the academy is, certainly the mainstream legal academy. So that some of the more enlightened members have come and gotten on these trends in the years that followed, and then obviously there's a number of more junior faculty, which is great, that have just said, well, why wouldn't I want to do that? That seems to be the right way to handle this. But that's kind of what we've seen. The other thing is kind of, I'll just say, I'm speaking on behalf of Mike and I, we just sort of personally decided we try to push these ideas like 12 years ago, and we sort of said, we're not going to argue with people who just want to argue. We're just going to go out and do the stuff, and we'll let the chips fall where they may. And so we just started doing things. We started publishing things on our blog and publishing a bunch of papers and trying to, show what could be done with these methods. And it wasn't all perfect, but the idea was kind of direction. This was the right direction in our view that things should head. And so the other thing we did is kind of get into the commercial side of things. And that's been very interesting because it does help, in my view, sharpen your sword a bit and focusing on kind of, I'll go through some use cases where I will say spending some time on the commercial side has been helpful in terms of zeroing in on those. One of the things that we focused on is trying to make our tools open source and available to people, even while kind of trying to do a commercial thing. We had a number of adopters in this space, and then we sold our company a few years ago to this company called Elevate. So I'm Dan Katz from Illinois Tech, and I'm also at Bucerius Law. So I'm a core faculty at Illinois Tech, Chicago Kent College of Law, affiliated faculty at Stanford Codex, and together with Dirk Hartoon, we help run the Center for Legal Technology and Data Science at Bucerius Law School. I'm also very thankful that I had the opportunity to be the Jones Day Professor of Commercial Law. Things got pushed back a little bit. I'll be coming out all things. I mean, if all things hold here in a couple months. So I'm very, very happy to finally be able to have my in-person version of being a visiting professor. So I just wanted to say at the outset that there have been a few gatherings along the way that I think have been important to help us get to this moment, which is have meaningfully advanced either the commercial side or the academic side of these ideas. So I just wanted to highlight a few of those. This is an old one, but a good one for me. Over 10 years ago, this was a very good program at Houston. I had the opportunity not to meet Stephen Wolfram directly, but I did meet Stephen Wolfram's robot here. This was my version of Big Bang Theory. So that's Stephen Wolfram's robot. See, he had so many presentations to give, he would just mail robots to various places, and then he'd show up and joystick himself around the room. So anyway, that's as close as I've gotten to meeting Stephen Wolfram, but I one time almost touched greatness. So a number of events on the commercial side that I was happy to run, these reinvent law things almost 10 years ago now. This was a good program that Ted Sickelman ran at San Diego. Thomson Reuters has been helping spread these ideas commercially, which has been good. And there's been other programs around over the years, I won't go through all of them, that have helped push these ideas further and further out into either industry or the academy, including in the field of complex systems a number of years ago. And back at Michigan, there was a program 5 years ago on this. This was a really good event that Ryan Whalen ran. Seems like with COVID, it seems like 500 years ago, but it was actually only 4 years ago. This was probably the coolest place I've ever been to a conference. This was like this beautiful cathedral in Maastricht. But and then this program that Pierre Paolo JB and I helped organize last year for Frontiers in Physics. Of course, ICAL has been on this beat for a very long time and been running conferences since 1987. And of course, Stanford Codex has been running their Future Law Conference for a long time as well. So I would be remiss if I didn't mention all of these events. They've helped us get to this moment. So it's my great pleasure to be here today. And I want to thank all the organizers. This is the time zone is a little tricky, so I'm going to try to watch some of the videos later for where I am, but I wasn't able to go to everything. But I think this is probably the best collection of technically inclined papers that we've seen to date. It's really good. It's really good. So congratulations to SMU for organizing this. I hope it's an annual tradition, maybe even fully in person. We can only hope. So my opening statement today is this: the journey we are on is a technical one. This is a technical journey. And so I just wanted to say something about this technical aspect. As this field matures, I think it's incumbent upon us to help press forward on the actual scientific and engineering exercise here, as opposed to just the mere colloquial use of law and computation. I think it's okay to have some of that, of course, as well. But if we really want to move these ideas forward, this is a technical journey that we're on, and that's why I'm very impressed with the papers. It's just an end-to-end, very, very solid group of papers. And so we need to continue to have more meetings like this to continue to move the scientific agenda along, push forward on the technical side of things. And I think we have to continue to tell the story of this field, because we need to direct funders and schools and faculty and students to support the key work in this area. Because if I have to be direct, some of the resources and so have been directed to things that are not really going to bear fruit from the technical perspective. And so it's incumbent on us to show the way to others who don't really spend time as we do kind of focusing on these topics. So that's one of the charges I want to leave you with here today. We have to continue to tell the story of this field to as many people as will listen. Mostly by doing it, because you can only argue with people for so long. So you're on the road less traveled, but I think you'll find that it has a lot of intellectual returns and personal satisfaction. So I think, to me, it's very obvious that the field of law needs a productivity revolution, and in order to meet the challenges, the governance challenges of the 21st century. And so my second opening point is, I just want to highlight what I believe is ultimately the problem we're trying to solve here. Whether you're a big company, a small business, an individual citizen, we have a complexity challenge in this field. Law has a fundamental complexity challenge. And if you take a step back and you say, what is it that drives the demand for law or lawyers or what have you? which, you know, if you're an economist, you're going to call units of legal production. Why do we even need all this stuff? It's complexity. Social, economic, and political complexity manifests in our domain as legal complexity. And so it's hard to define this. I spent a lot of time on this. Many of you that are joining us today have spent time on this topic of legal complexity. It's hard to define, but it's something I spent a lot of time focusing on. Kind of every way you cut it, done in a bunch of different ways, you see significant growth in legal complexity. So even if you disagree with a measure here or a measure there, it's sort of like the aggregate case is a pretty strong one, as I see it, you know, including these two most recent papers that I would highlight. Here we see like really significant growth in law and regulations in two large industrialized countries. I believe these trends would generalize broadly to the kind of industrial, large industrial countries space. So to me, the question is, how do you match that complexity with the appropriate complexity mitigation tactics? Mixtures of people, process, and technology, emphasis on the third one. Designing more scalable systems. The legacy model in this field has been, anytime you see a problem of complexity, just throw more people at the problem. Lots of complexity, lots of lawyers. I think that has practical and economic limits, and we have priced large numbers of people just out of the market for legal services because of the inability to configure people, process, technology bundles that will actually help them solve the problem. So the approach to me needs to be pretty fundamental, leverage the best of science and technology. So I have thoughts on this here on complexity mitigation strategies, but the bottom line is the road runs right through these ideas. Through these ideas is where, that's the path where these ideas, this productivity problem's got to get solved here. At least we got to play a positive role in all of that. So in the remaining presentation, I want to kind of talk about a big picture of sort of three eras kind of leading in computation. I want to talk about some use cases and then give you some closing thoughts. So three eras: analog, digital, computational. Since this is an overview talk, I wanted to take the widest possible view on things. So if you take the widest possible view, we've been on a very long journey, actually, from hunter-gatherer societies to a highly complex global economic order. And that 5,000 plus year journey requires scaling trust and building institutions that help lower transaction costs. That's a kind of a broad stroke way to define economic history. And that has been facilitated through the development of institutions, analog, digital, and computational institutions. And so whether it's a technical or technological or otherwise, we have managed to develop different types of legal innovations that solved problems on this triad: law, finance, technology, typically. Those three things tend to co-move through time and space. And so, you know, this is a very broad sweep through history, but there's some key moments along the way where we've managed to develop, you know, legal orders that facilitated more transacting, risk shifting kind of innovations or risk management innovations that allowed more transaction and more economic growth to occur, which, you know, has led to human flourishing. So, but I want to focus on three recent eras, maybe roughly 150 years. You could break it into three buckets: analog, digital, computational. And here's some of the animating technologies that you see here. I'll go through each one briefly. And one thing is that you can do is, if you look at these three eras, there's a variety of trends that kind of lead you to the present. But the key thing is that items sort of layer cake on top of one another, the eras do. And so maybe an idea here combined with an idea here in another is actually the innovation. One alone or the other alone isn't enough. But so there's a combinatoric sort of effect to all of this. And at the end, each of these transitions requires an effort to take our public and private institutions and kind of transition them. And often that has been facilitated through public infrastructure and academic research and development. So that's kind of where we come in. Okay. So in the analog era, you know, you see these are some of the animating technologies. We have the beginning of network telecommunications. So Morse and the telegraph, we'd be able to spread more information quickly. past, this is the original texting. But you're able to spread information more rapidly, at least over the telegraph. Then we're able to speak to one another over a telephone. You throw in automobiles and you're able to lower the geographic distance between individuals. And we get we have computing. But it's important to say, when we talk about computation, I just like to always point out, this is a computer and this is a computer. And if you use the word computer at the beginning of the 20th century, it meant person who computed things. There was no notion of all of this, but we were still doing computation. It's just all roads led through this, whether individually or working collectively. So people would sit in rooms collectively and compute things. To the extent you had to calculate something that required a coordinated computation across many individuals, it didn't really get done. It was too expensive. So the amount of computing that was done in the way we would think of it today was fairly limited. But that's kind of the most important part of the story is, we start to get just the beginning of computing. Now, this is like the thing that's the size of like a huge room. And this is a analog computer from 1949. We get into the digital era, and analog computing becomes digital computing. So you go from this to something to these, like here's the Mark I. It's still like the size of it's a very, very large computer, and it's still highly mechanized. You can take a look at it there. But then we get personal computing. So the number of people who have access to computation is increasing with a UI and so forth. People don't have to necessarily know how to program to use a computer. So that's a democratization exercise. We get faster processors, faster transistor count per chip. And it's cheaper and cheaper. We start to nanoize a computer. So computer's not just like some massive thing that sits on your desk, but it's in your hand, and it's also your phone. Computers begin to get connected, and we begin to try to transition in this period to physical marketplaces and move them into the digital sphere. And so what happens? We get a lot of this is obviously partially the story of Amazon, but we have small niches that are able to be created where otherwise a traditional store can only sell the top, say, X number of products because they only have so much shelf space. I mean, the story. The other thing we have to do is graft our analog institutions into the online digital world. And so that becomes a big charge of the time. And then that kind of brings us right into this edge of this computational era. Now, the World Economic Forum calls the period we're moving into the fourth industrial revolution, and by which they mean this world of cyber physical systems. And I'd call it the computational age, but that's okay. In other words, we're not really just in the digital age. We're something more fundamental going on in this early computational age. And so maybe I'd call it that because we have this blog, I don't know, but some of the emerging elements and the combinations thereof are what are really interesting is you put these three technologies together and you get something that's more interesting, frankly, than even one of them alone. And that's really largely unexplored terrain, is connecting all of these technologies together. That's where a lot of the innovation is actually happening right now, including not only alone, but in the additive sense. But I mean, there's a sense, of course, in which the law and legal institutions are already computational. I mean, you can think of every lawyer as doing a computation, a lot of them done here. And obviously there's this this philosophical view that the universe is a computer or something like this. I'll leave you to that to take a look at. But outside of biology and physics, most institutions do perform computations. They're constrained by certain things like norms and the rules and the norms that govern them. There's mechanisms like appellate review and stuff like this. But I think one of the fundamental ideas is most of law is still being computed by people's minds in a structured process. So the rise of this computational era is in part about reconsidering the role of human-centered expertise and perhaps how we might implement legal rules. More on that in a minute. But so I view this as the broad arc here: analog, digital, computational. The analog is kind of chaos and complexity, some degree of process and predictability. and reinvention and value creation is really what we need to be focused on. So how is law going to fit into all of this? Well, I think there's at least two dimensions to this. One is kind of how might we use computational methods to assist in the existing systems we have. So we have a system today. We might be able to use computational methods to provide insights into how that system operates and how we might improve it. The more fundamental idea is to actually how the law might be implemented in new computational systems. That's the more fundamental idea, the harder of the two. You know, I would say, people say, well, what's that? What's the difference between this and like, you know, empirical legal studies? I would say like empirical legal studies, I'd say if the method involved kind of originates from computer science, we'll put it in the computational bucket. If it comes from economics or something like that, we'll put it in the other bucket. So things like this are on the computational side of ledger. Programming languages, machine learning, NLP, network science, that's all on the computational side of things. All right. So now I'd like to talk through some use cases and kind of walk through this analog digital computational thing. So I want to, the few use cases where computations, I want to cover some public law and private law examples. There are many others one could put forth. These are just kind of a few to kind of that are chosen to highlight. And some of them are descriptive exercises, and some of them are focused on how one, like the implementation challenge. So let's start with this one, contracts and transactions. First of all, what is a contract? Well, I mean, a contract is a way for lawyers to make money by negotiating over nothing. That's a joke. I'm here all week. Try the chicken. Anyway, a contract is, this is what the restatement says, a contract is a promise or a set of promises for which the law gives a remedy or which is recognized as a duty. Second restatement. Okay, you've got your law. There's some law in here. Don't let anybody say there was no law in here. I use the restatement. If you took first year law school contracts, you'd see stuff like this: offer and acceptance and consideration and possible, you know, things like duress and fraud and capacity questions about you know, the formation of agreements. Nice thing about old school analog contracts, sometimes called dumb contracts by people who want to poke fun at them. You know, these are three positive properties. One is that they're infinitely customizable, subject to the law. I mean, subject to legal limitations, the parties can kind of agree to all types of stuff, subject to kind of things that are not permitted by law. So that's a very positive property of them. Contracts are inherently incomplete. That's a long-standing problem. Contracts cannot specify in advance what can be done in every possible contingency. You know, they gave out a Nobel Prize for this. That's both a benefit and a limit, because if you don't go to the end of the earth on the specification exercise and you say, if we're going to do this degree of specificity and we're just going to let the background law compute it, do the rest of the compute, rather than try to specify it all. The other thing that's tricky about contracts when you take them as an artifact is they interact with the default rules. So they're default interpretation rules that a court might apply that are not necessarily written in. In other words, you can write a much shorter contract because anywhere there's silence, the court will fill the gap. That's a traditional move. So because they exist, these background default rules, the artifacts themselves are not the whole story. That's a hard problem. That's not what people always expect. Like, they come in from the CS side of things. They're very thrown off by that. Now, they're subject to interpretation. That's a limit because one of the ways people solve for that is they tend to converge on terms that have been interpreted in the past. So obviously they also borrow from stuff in the past, but in theory, we could agree in the agreement to an interpreter, a machine, an algorithm, or an arbiter. That's a classic traditional thing, but you could have a machine be the adjudicator of something, theoretically. They're expensive to draft. I mean, that's a limit of analog contracts. Now, clause banks and templates and other streamlining methods do help reduce costs. And then there's this challenge of managing the rights and obligations. Now, I'll say more about that in a second. But I just want to remind everyone that contracts, now we're out of first year contracts, now we're into contracts in real life, IRL, in real life. In real life, contracts exist in a life cycle from birth, meaning I need an agreement, all the way around to this agreement Does it renew? We need to create a new agreement. There's a life cycle. So I want to talk through that life cycle and talk and sort of highlight some stuff. So starting early in the contract life cycle. Oops. We have digitized contracts in the sense that they are born versus via computers. But in a commercial context, contracts are not always take it or leave it. They are actually the byproduct of negotiation. Sometimes we take it or leave it, like you click I agree and into that click wrap agreement. But sometimes they're the product of negotiation between the parties and their lawyers. On the path to the agreement, they can trade drafts back and forth, back and forth, back and forth. What's the purpose of the negotiation? Well, let's call it risk transfer tennis. I try to take some risk and push it to you, knock the ball over the net, and back and forth they trade the drafts. Traditionally, we use human reasoners or lawyers as the computers of legal risk. But many organizations do provide what might be called analog assistance to guardrail that process of negotiating agreements. So what is it that we provide humans to guide their computation? Playbook. That's information technology. It's analog IT. It's something like in a binder, actually. But it's a playbook. It says, well, do this, don't do this. What's a contract playbook? It's a mixture of rules and data regarding how to negotiate an agreement. You can accept that. You can't accept this. Here's your fallback provision. If they want this, you have to get this vice president's signature and so forth. So it's there's a workflow in it, and there's rules and data in it. And so the question becomes, what if you wanted to implement a computational version of this idea? That's a big question in the industrial space right now. Well, one of the things you would need is data exhaust. In other words, it would be useful to see how people have negotiated them in the past. Now, you're not bound by that, but it's certainly a good place to start. And where might that exhaust live in the negotiating process? Well, they live in the contract management system du jour called Microsoft Word and people's email. Now, people have spent a lot of money in industry buying contract management platforms that people don't really use that, especially on the negotiate. They put the last version of the agreement, upload it, but this exhaust is often left out of the process. And so that's really where one of the frontiers is here. Can you build a bot that can negotiate contracts? Now, there's a lot of clever ways to get to this, but this is where a lot of the industry is right now trying to build. How long, probably a better way of framing is, how well or how long could you negotiate with a system before you realize that it was a machine redlining your agreement instead of a person? You can still have humans in the loop, by the way. So the question would be actually, how many of the things could the machine properly redline, and how could I, as they got more data points, kind of improve the fidelity of that process? That's going to take you into this direction: NLP, reinforcement learning, and a rules engine. And that's really that's an active problem in the space, and a computational playbook to negotiate contracts. Okay, so back to contracts now, further in the life cycle. What are some of the examples of data in contracts? Well, all types of data. These are just some of it: tokens, words, clauses, definitions, parties, counterparties, third parties, entities, geopolitical or otherwise, other named entities. There's also entailment. There's connections between the agreement, both within a document and across documents. So there's a reference across or within the document and across. Obviously, contracts are more than just data. Contracts often specify a higher order range of relationships between entities. They have, again, rules, references, computations, and obligations. Contracts do want to be computable on a continuum. Doesn't mean you have to be fully end-to-end computable, no humans in the loop, no nothing, just a continuum. They're really already partially computable, just to who's doing the computing. I want to pick this example. This is got it from the SEC, the U.S. Securities and Exchange Commission's website. This is a publicly disclosed contract. You can download this yourself. There's a master services agreement. It's not the fanciest contract of all time. It's not the simplest one. It's a kind of a in the middle range. Okay. And I just want to take you to one thing here in this agreement. This is a very important part of the agreement. This is the fee amount, like who gets paid how much and when. That seems important. That clause calls for a computation. You got to know when I get paid 10 million, then 12 million, then 15 million. But then I need to know when the agreement starts, so I know when the jump happens after the first year from 10 to 12 million. It also is an obligation, by the way, on the other side. And to calculate this, you actually need both internal and external data. This is just one clause in one agreement. You need to know this. Well, we have a lot of inflation now. Sometimes I'd give this example. If you're like, what's inflation? Guess we know more about that now than, we've got like a lot of inflation now relative to what we've had in the past. But like, in order to calculate this, which is relevant to that, I actually have to go in and figure out the consumer price index of the United States, which is a piece of information that lives on that website. And it's not even just to know that, you have to know the spread between the two of those. But that is a formula that is waiting to be calculated. But to actually calculate it, there's a bunch of implicit and explicit rules that have to be made surface in order to do what, by its face, a human could calculate in a relative straightforward manner. So the challenge is non-trivial here. But that's the terrain on which we're trying to operate. So contracts want to be computable. They want to be able to push and pull data. So let's talk about this one now. LIBOR. LIBOR is the London Interbank Offering Rate. There was a big scandal about it. It's a floating interest rate that's in a lot of financial instruments, and it's going to sunset. And there's something like $200 to $400 trillion of notional value that's tied to this rate. And there's been a lot written about it over the last few years because, there's a massive repapering exercise where people have to go through all these agreements and substitute the fallback rate if it's existing, or repaper or renegotiate these agreements. Some of these are for a lot of money, so it's like a lot on the line here. But if these things were structured data objects, this would not require this massive effort that's going on right now. I mean, banks have spent like $300 million a bank on this task. On the commercial side, worked with Clifford Chance on this as an example, but and here's the next one up for grabs. So the failure of contracts to really be fit for purpose costs actually a lot of, it's actually a dead weight loss to society. This is not really helping, except for if you're the lawyer that gets to do the work. So this is a problem in need of a solution. I get concerned sometimes that, and we all do this, especially in academies, that we're solving a problem that doesn't actually need to be solved. This actually is a problem that needs a solution. So we've arrived in the digital era, we put things online. The thing we've often done is never really rethink the underlying exercise. So even contracts today are often analog objects stored in a digital medium. Analog objects stored in a digital medium, by which I mean, if they typed it on a typewriter and they did it in Word, the thing looks exactly the same. It just happens to be on a computer screen, not on a piece of paper. Analog objects stored in a digital medium. So that is chaos and complexity. What happens sometimes is people say, okay, well, we're going to move and we're going to at least try to manage this. And so they create some framework to move contracts along. This is like industrialization here. They're not really changing the exercise itself. They're not changing the agreement. They're simply spending time, trying to move the process of contracting along. But what about a more valuable version of the actual drafting exercise? And I'll point you to this example here. This is a hypothetical agreement about crop insurance, but the idea is that the driving dynamic in crop insurance is, was there a drought, and the corresponding diminution in yields. And you get insurance payout for the difference between, hey, the normal crop yield and the yield you got because of the drought. Now, what they normally have done historically is they peg those to yield, so they have to come out and actually see what your yields are. But another way to do is to peg it to weather, and to have it be. But then, in order to do that, you have to have a truth maker, as they call it in crypto land. You have to have some validation of what the rainfall was, what the temperature was. And so In order to make this contract on the computable side work, you have to be able to take a data feed and process it subject to some rules and output it to another system and connect all this stuff up. So you have a natural language agreement combined with an embedded computation. This is kind of if you don't like the example, this type of thing works on a lot, this sort of schema works on a lot of context. The key is to be able to have a specification of the underlying rules that actually works. Now let's go to the late stage of the contract lifecycle. In an institutional environment, what happens is people take up rights and obligations and turn them into policies and procedures. So as noted earlier, contracts feature rules and obligations. So rights and obligations management is a big task within this space. So you've signed an agreement, and now as an organization, and now somebody has to be responsible to make sure you either get what you're owed or you do what you're supposed to do. That leads to systems of controls and reporting, and with an overlay of auditing and compliance. So let's just take a simple term. You have to delete somebody's data within 24 months. Well, that has to be embedded in the policy and procedure, connected with controls and reporting, and there needs to be audit and compliance to ensure by somebody that actually happens. Organizations really struggle with this, translating things in contracts to actually make the organization do the stuff they're supposed to. And even it's not even being malicious. They just can't get, it's just too disconnected. So this is a big thrust here as I see it. I'll come back to this kind of idea in just a second, outside of the contracts context. But let me transition to dispute resolution. So Richard Susskind highlights this question in his recent book, is the court a place or is the court a service? Well, I'd say in the commercial context, the court is a service. Dispute resolution is a service. There's alternatives like arbitration or something like this. So, some countries have understand that the law itself and dispute resolution is actually a part of the industrial strategy. I mean, the UK is this is a big theme going on in the UK right now about the economic value of English law. Dubai has made this as part of their industrial strategy, and certainly Singapore has as well. I think it's very rational to say, if we're going to be the financial hub, we also need to be the arbitration hub because things move in threes. Law, finance, and technology tend to move in threes. They tend to co-move together. So it's very logical and a rational decision to me to try to stake a claim on this. But kind of following the broader theme here, if you look at dispute resolution, analog is paper records and documents, in-person processes, and lightly stored, if any, case metadata. We've had an experience since the pandemic with a lot of courts around the world having to do some sort of a virtualized process. It's not gone exactly swimmingly in all instances, but that's, I guess, some degree of digitization, digital documents, enriched scope filings, but this is all kind of storing the record and having processes that aren't all kind of in person and through paper. But the question in the computational area, as I see, is how can we design dispute resolution systems implemented in software, even if we still have humans in the loop? That's kind of the question. So there's this modern idea of merchant law. If you think about the early days of the internet, first question is, how do we pay people? And second question is, if we get a dispute, how do we solve our problem? So PayPal is the one you're probably familiar with. Maybe, many of you would know Modria, but if you didn't, they're a good example of how do we do dispute resolution at scale. They're not necessarily a perfect company, but like relative to no help, these platforms can't exist if there's not dispute resolution. People will never come back if they don't get their good, or if they're left out and they're dry, they just won't participate again. And so e-commerce in a sense depends on this at its core. So they have obviously a lot of data points there. They're a computational era company as I see it, and they were just sold to the biggest player in court IT a few years ago. Now, the question is, will they be able to bring ODR out through all these courts, all these places? Now, ODR got a big, with the pandemic, kind of moved to the forefront in a lot of people's mind. A lot of judges, it wasn't a big thing on their radar, but it is more now. So, hopefully we can have a more scalable version of the justice system, vastly, alternative delivery models. We're getting chat bots. That's good. That's a step along the way. Maybe we'll have a This is the closest thing I've ever seen to a robot lawyer. They keep talking about robot lawyers. They must be somewhere. So that's the closest thing I've ever seen to one. It's a robotherapist, the U.S. military created. So I think the academic community needs to play a constructive role in helping implement these systems. And I mean constructive, because there's a lot of people like to critique these things, but they don't, otherwise you just get what you have. In other words, you stick with the status quo, which is not that fabulous anyway. In a lot of instances. So the question is how to make it better, not how to make it perfect, because the status quo isn't that. That's, my view of it. But the third use case, I'm going to do 4 total, is, exploring the development of the law, common law and statutory systems. These are descriptive offerings, but a lot of what we do in legal research, we try to understand a trend or its connection, or points of law and how they're connected to one another, or how things are changing over time from a regulatory perspective. So from a data perspective, the common law systems feature a very nice sequentially produced documents featuring text and language, citation, and a document structure. And even civil law courts have this as well. There are a variety of modeling and representational choices you can make if you want to represent the law over time, or time slice, or over time. They can be modeled using network science or natural language processing methods or other machine learning methods. This is an example from Corinna Kapetz's example here, but from the German Constitutional Court, where you see these references that are embedded in a document and how they're connect out to other documents, and so you have a massive reference network in many legal documents. Now, that is something that has been explored in the scientific side of things. I mean, it's still early stages, but we've seen lots of these types of papers. These are some older ones looking at citation and reference networks, so you can understand some of the physical properties. I'll go through these, relatively quickly, but you get a feel. I mean, this is going back a number of years now, some of our stuff as well. There's some statistical properties you can learn about legal systems. There have been a lot of efforts to apply network science to courts around the world. These are just a few. And there's an application of network science to statutory materials as well. Here's just a few of the efforts to date. In France, Hungary. This is an EU example. This is our work on the US code. We investigated a single time slice of the US code. And this is kind of codes tend to be hierarchically structured like this. So that you get a tree-like structure originating out. They often have reference networks, so citation networks. So this is the United States codes. So like, for example, in tax evasion, the tax code it borrows ideas from the criminal law, Title 18, Title 26 share relationship. And this is the entire network visualized. So you have like this is like the whole code. It's 20 something million words long. You have this plus this. When you overlay them, you get that. And that was, by the way, as of 12 years ago. But when you do the time dynamics, you get it even another perspective. And that's what we've been exploring in our most recent work. And I'd like to see more people, work on this topic, because there's much more to be done. I mean, obviously, this is the 10,000-foot view, which is a lot of growth in the law. Judicial citation networks, you can model case-to-case reference networks. They kind of look like this. Time goes forward, reference always go backwards because you can't cite things in the future. And so it looks like this. You can see the full video over on Vimeo. Is that playing for you? But you see rapid acceleration in this over time. Okay, so So the final thing I want to talk about is the implementation of code, of law as code. So there's this idea of law as code, which is very attractive. It's a very attractive idea. I mean, if you spend any time with CS type ideas and you look at the law, it seems so logical. It's a tricky subject and a detailed subject, and something like, it's worthy of a whole presentation in its own right. But, obviously there's been this longstanding kind of theoretical or metaphorical idea of law as code going back. This is a very popular treatment of at least the analogy. There's this, which is a more, stronger effort to really try to carry through on the idea, at least metaphorically. We've been working on, Corinna and Dirk led this, the more modest idea is, what could I learn from computer science about how to craft like legal codes better? The more compelling thing, obviously, that everybody really wants to do is code as law. So code is the implementation of law. That's what everybody wants to do. It's a hard problem, okay? There have been efforts to try to do things like this. Automatic embedding of statutes into systems has proven to be a very challenging problem. The thing is, though, organizations somehow, some way, have to ingest legal rules. They have to do it. And so let's start with the legacy approach to the problem. This has to be done unless you're running a completely rogue organization. You have to take stock of what the law is somehow and make the organization follow the law. Okay, so here's how it works. If you don't think about computation or whatever, you say, okay, there's a statute of regulation, which might get reviewed by a lawyer, like an outside counsel who might write you a memo. That memo will get translated by somebody a compliance officer into a policy or procedure. And these organizations get huge numbers of policies and procedures. And oversight of that policy and procedure might be reported through somebody keeping track of a bunch of stuff in an Excel spreadsheet. And this is how a lot of policy implementation and oversight is done, through Excel. That's really often the state of affairs today. So that's not horrible when the execution layer for business was people and natural language for everything, but that's not really the speed at which things move today. It doesn't matter. The underspecification and misspecification isn't as problematic in that context, but as you begin to try to do digital transformation, the lightly digital approaches looks like this. Same kind of first three, but now what somebody has to do is translate the policy and procedure into technical requirements. So somebody does requirements gathering, a business analyst, who then hands that to a engineer whose job it is to implement something that came out 5 steps before them. So suffice to say, that's an opportunity to have a serious loss in translation, is the rule itself and the final implementation, and the last step doesn't look like the first step. It's very easy to get a misspecification or an inability to really implement, because to the extent you make the implementation the way that the law actually will be handled within the organization, that actually is the law of the organization, even if it isn't the law of the country or the state or what have you. And so remember, that's the procedure for one law at a given moment in time. But as we know, time doesn't stand still. In the macro environment, we get more laws and regulations. They change, they grow more interdependent. That's the big focus of our work, has been to kind of try to document that. So you just start this whole cycle anew. By the way, how do you even know there's been a change or a law and regulation? Well, if you're, say, a global company operating in jurisdictions all around the world, you need policy surveillance. In other words, you just have to keep track of what has changed. You can do that analog, digital, or computational methods, but like somehow, some way. I mean, the classic first-year associate task is the many jurisdictional survey of some topic. This is what they do here. This is what they do here, and trying to track all that. And then at the end of the day, it's supposed to get consumed in an organization somehow. So there's increasing interest in both the academic and commercial sphere into this, which is a very practical but hard problem. I'll give you this example of these companies here on implementing privacy regulations, CCPA, GDPR, but trying to do it by design. Remember, like, the engineer is the one who's going to decide what data set, if left with no guardrails, what data set is they're going to use, regardless of, without knowing the details or contours of GDPR. So these folks are trying to create, it's not an advertisement for them, I'm just giving them as an example of a multi-stakeholder platform which allows organizations to engage in what might be called regulation lifecycle management. This is kind of what it looks like. So trying to translate all of this into a system that can be used by many stakeholders and that has an implementation of the rules relative to these types of applications. This is kind of what it looks like. But here's the problem. How do you know that a data object's actually problematic? In other words, where do you get the rule sets from? How do I know if this data field is acceptable or not? Well, this is what we're seeing emerging in the space. Third-party marketplaces for rule sets, which you can take and fuse with the data model. So Concur is like an HR system. MailChimp is for like sending emails and stuff. And so they have data models that sit behind these. So what you need to do is say, this particular field in this data model is off limits relative in this jurisdiction, because let me download the rule set of that jurisdiction, because that's what's going on in this example. And you can take that sort of principle across. So this is really regulatory compliance by design. And this is a big idea in this space. And the economics are sensible. And you say, well, who's going to spend the time building all those rule sets? Remember, every organization either has to do it, or you create a marketplace and people make the investment in creating the rule set for each, say, commonly used application, and they can amortize it because they can build it once and try to sell it to many, even if there's some degree of customization that's required. Okay, so I tried to walk you through 4 examples there. My closing statement is this: I think we are all trying to work to contribute, working to try to contribute to the improvement of the law. And I view this path toward computational law as really a grand scientific and engineering exercise. It's not an easy one, but their goal, I think, is we want to make the work to make the law more fit for purpose to help solve the complex governance challenges of the 21st century. So on behalf of myself and my colleague Mike Bomarito, this is our journey and these are our thoughts. Thank you very much for your attention today.
Hi, thank you. That was a great talk. Does anyone have any questions? I'm sure we're all so much to take in. I'm sure we're all kind of formulating what is the best way to ask.
Well, anybody can hit me up on Twitter if they, I might not get it to tomorrow morning, but I don't want to put you off schedule, but
yeah, I think we do have time for questions.
Okay.
I think since everyone seems to be still warming up, let me perhaps ask one that I have. I'm curious about how you think we could actually prepare students for this kind of future that you've described. Talking about this future of computational law, some of the frontiers that you've mentioned. What kind of the skills do you think we need to kind of teach to the next generation of lawyers and people? I know you've been doing a lot of work on this space as well, so I'm just curious to hear what you think about this.
Well, I mean, it sometimes always turns into should they learn to program or not. I don't know if that's like 100% necessary for every person. It wouldn't kill them to learn it, but I do think it'd be helpful for people to engage in what might be called computational thinking, which is a lighter version of these ideas. So they have some familiarity. I think that you know, some degree of a polytechnic exposure, especially if you're interested in anything I just described, would be helpful. And you know, some of our students have that background through some way or another, and some of them don't. And so some sort of an on-ramp is a useful thing, so they can start maybe with a, if they're interested, a relatively modest amount of knowledge and climb the ladder, so to speak. I think, you know, that's what, at least in my school, that's what I try to do, is create a program that, you know, where people could come in at different levels. I mean, we have people who are computer science undergrads, or people who like don't know anything about it but want to know about it. So we want to create opportunities that, regardless of your knowledge, to learn more. I mean, it takes years to learn these things. These are hard ideas. I mean, learning the law is a hard thing too, by the way, obviously.
Yeah, thanks for that. I think some of the motivation behind this question is because you've described the challenge that we have as an engineering challenge, right? A grand technical challenge. So that's quite inspirational, but personally speaking, it's also a bit scary because I don't have engineering training myself, and I think a lot of colleagues are not formally engineers, at least in the degree sense. So I guess the question also, not just for the students, but for people working in this space, or maybe new joiners to the research space, what kind of, like, do you think it might be to maybe push the extreme, mandatory to work with somebody with a CS degree or a PhD even, or what kind of model do you think would be ideal?
I think the students say that go to an SMU are going to be of a sufficient, you know, they're going to be smart enough, they can learn the stuff if they really want to. It's really a question of, like, you know, that they have the capacity. It's more of a question of will and time and focus. And you know, it's not like everything you ever learned was in school. I mean, you have to our job is to set a foundation in people and allow them to continue to build on that foundation. It's not that we make them future proof the second they leave and then they never have to learn anything again. That's not correct. And I don't, you know, the like, do I need a degree in this? How about just like learn the stuff you need? Try to just learn the stuff as the and that I'm more interested in that than like the formality of it. Let's put it that way.
Thank you. And I think we actually have a question from Ming in the chat. Can you see it?
Yes. Yeah, I mean, I gave away, and I give them away. These are ideas that are already out there. But I mean, I do think, you know, I think contracting and compliance are two of the biggest things that organizations struggle with. So getting the organization connected, I mean, it's from an IT perspective, many organizations are totally fragmented. And so being able to connect the systems together to help them comply with the law is that's a really target-rich opportunity for entrepreneurs, to me. Is, can you focus in on perhaps just one problem to solve where you connect those? I mean, I gave you the GDPR one, but like obviously that one's people have done a lot of work on. But like there's going to be some new regulatory challenge that organizations will struggle with, and they need help. Right? They need help. It's sometimes a real mess inside of places.
Any final questions from anyone? Okay, if not, please join me in thanking Dan for presenting all the way from Chicago. No, it's late over there, so we won't keep you any further.
Okay, thanks everyone. I'm looking forward. I'm gonna watch the videos later, but I got my kids I gotta go like manage with. So thanks a lot, and I look forward to visiting SMU very soon. Thanks everyone, and seeing all of you in person someday again. Bye-bye.